Good evening, everyone. This is Manilin Swazo, a secondary student of Bachelor of Science in Criminology, Section A. So, my topic is all about the whole chapter 3, the Provision Law of the Philippines, Presidential Decree number 968, as amended by Republic Act 10707. Philippine Provision Law. On July 24, 1976, Presidential Decree number 968 was promulgated. This law applies to adult convicts and first-time minor drug offenders by virtue of Republic Act 9165, particularly Section 70. The law which is more popularly known as the Comprehensive Dangerous Drugs Act of 2002, and child in conflict with the law, CICL. Under Section 42 of Republic Act 9344, or the Juvenile Justice and Welfare Act of 2006. However, Presidential Decree 968 was subjected to amendment of others statute. These amendatory laws are as follows. Presidential Decree number 1257, effective upon issuance on December 1, 1977, amending sections 4.7, paragraph 1, 15, and 33 of Presidential Decree 968. Batas Pabansa 76, effective upon approval by the President on June 13, 1980, amending Section 9 of Presidential Decree 968. Presidential Decree number 1990, promulgated on October 5, 1985, and took effect on January 15, 1986, after 15 days from the date of its publication in the Official Gazette on December 30, 1985. This law amended Section 4 and 9 of the Presidential Decree 968. Republic Act number 10707, an act amending Presidential Decree number 968 as amended. This act, which is an consolidation of Senate Bill number 2280 and House Bill number 4147, was passed by the Senate and the House of Representatives on November 5th, September 15, 2015, and September 14, 2015, respectively. It is approved on November 26, 2015 by President Benigno S. Aquino III. Republic Act number 9344, or the Juvenile Justice and Welfare Act of 2006, amended Section 4 of Presidential Decree 968 to read as follows. Section 42, provision as an alternative to imprisonment. The court may, after it shall be convicted and sentence a child in conflict with the law, and upon application, at any time place the child in provision in lieu of service of her or his sentence, taking into account the best interest of the child. For this purpose, Section 4 of Presidential Decree number 968, otherwise known as the Provision Law of 1976, is hereby amended accordingly. Other law prescribing disqualification for probation. Omnibus Election Code of the Philippines, Batas Pambansa 881. Disqualification for probation, even the penalty of imprisonment is within the coverage of Presidential Decree number 968. However, Section 57 and 70 of Republic Act 9165 requires the applicability of the provision law, provision and community service under the Voluntary Submission Program. Section 57. Provision and community service under the Voluntary Submission Program. A drug dependent who is discharged as rehabilitated by the DOH accredited center through the Voluntary Submission Program but does not qualify for exemption from criminal liability under Section 55 of this Act may be charged under the provisions of this Act but shall be placed on provision and undergo a community service in lieu of imprisonment and or fine in the discretion of the court, without prejudice to the outcome of any pending case filed in court. Provision of community service for a first-time minor offender in lieu of imprisonment. Section 70. Provision or community service for a first-time minor offender in lieu of imprisonment. Upon promulgation of the sentence, the court may, in its discretion, place the accused with probation even if the sentence provided under this act is higher than the provided under existing law on probation. Implied applicability of the Probation Law. Optical Media Act of 2003. Republic Act 9239. Repealed Presidential Decree 1987 or an act creating the Videogram Regulatory Board. There is an express provision under Presidential Decree 1987 that the provision law shall not apply in cases of its violations. However, under Republic Act 9239, there is no longer a provision that clearly excludes the application of the provision law in case of its violation. Hence, since the later law is more favorable to the convict and applying the purpose and intentions of the provision law, persons who are convicted for violating the law shall be allowed to be placed on probation. The purposes of the Philippine Probation Law: promote the correction and rehabilitation by providing the offender with individualized treatment, provide an opportunity for the reformation of an offender which might be less probable if he were to serve a prison sentence, and prevent the commission of offenses. Section 2 of Presidential Decree 968. Advantages of provision. It prevents crime by giving freedom and rehabilitations only to those convicts who are not likely to recommit violation of penal laws. It protects the society by placing the probationer under supervision of probation officer. It conforms to the concept of restorative justice. It gives another chance in life and provides opportunity to be rehabilitated to the penitent convict. It prevents first-time convict to become hardened criminal, more economical or less costly on the part of the government. It restores successful probationers his civil rights. It makes the probationer a taxpayer instead of tax eater. Statutory attributes of Philippine provision law. Provision system. The provision system established in the Philippines has at least three important characteristics that make it different from other provision system of other jurisdiction. And these are: first, it is a once in a lifetime affair, meaning that a convicted person can only avail to privilege of a provision once in his lifetime. Second, selective application. Provision is made available only to those convicted of certain crimes. Crimes against national security, like treason and espionage, are excluded. Next, person under provision retain their civil rights, like the right to vote or practice one's profession or exercise parental or marital authority. Next, the suspension of the execution of sentence in conditional. Violations of any of the condition may cause revocation of the privilege. Condition of provision to be imposed by the court to protect public safety and to foster the rehabilitation and reformation of the probationer. Jurisdiction of the court is continuing in character. Post-sentence investigation report is mandatory, which will serve as informational guide for the court's decision in granting or denying the same. Supervision, guidance, and assistance by the probation officer over the probationer. When probation order become effective. So, it should take effect upon its issuance, at which time the court shall inform the offender of the consequences thereat and explain that upon his failure to comply with any of the conditions prescribed in the said order or his commissions of another offense under which he was placed on provision. Persons disqualified to be placed on provision based on Republic Act 10707. Section 9, disqualified offenders. The benefits of this decree shall not be extended to this. First, sentenced to serve a maximum term of imprisonment of more than 6 years. Next, convicted of any crime against the national security, who have previously been convicted by final judgment of an offense punished by imprisonment of more than 6 years, 6 months and 1 day, and or a, a fine of more than 1,000 pesos, who have been once provisioned under the provisions of this degree, and who are already serving sentence at the time the substantive provisions of this decree became applicable pursuant as Section 33 hereof. Arrest of probationer. Subsequent dispositions. At any time during provision, the court may issue a warrant for the arrest of a provisional for any serious violation of the conditions of provision. The provisioner, once arrested and detained, shall be immediately be brought before the court for a hearing of the violation charge. The defendant may be admitted to bail pending such hearing to such case. The provisions regarding release on bail of persons charged with a crime shall be applicable to provisioners arrested under these provisions. Obligations of a probationer. Present himself to the probation officer within 72 hours from receipt of probation order. Report himself to the probation officer at least once a month during the period of probation, not to violate the conditions of his provision. Terms of condition of provision. Two kinds of conditions in provision. First is mandatory and second is discretionary. Mandatory or general conditions. To present himself to the probation office for supervision within 72 hours from receipt of the probation order. The discretionary or special conditions. Cooperate with his program of provision treatment and supervisor. Meet his family responsibility. Devote himself to a specific employment and not to change said employment without prior written approval at the chief provision and parole officer. Undergo medical or psychological or clinic or drug or psychiatric examination and treatment and remain in a specified institutions when required for the purpose. Advantages of provision. The implementation of the provision law will confer benefits and advantages not only to society in general but more so on the part of the offender and the government. For the society, the philosophy of provision is that the community is responsible for crime and its causation, that individuals can change and deserve a second chance, and that is for the greater good of society that offenders not be summarily eliminated from productive life but brought back to its fold in the quickest and least traumatic way possible. For the victim, provision provides restitution in favor of the victim, hence justice is considered served. For the convicts, in the absence of provision as an alternative in incarceration, a convicted individual would accumulative suffer the loss not only of family contacts and jobs, but also with the mass treatment in prison, loss of privacy or any privileges requiring exercise of personal freedom of choice. For the family of the convicts, it does not deprive the children of their parents and a spouse for his or her husband or wife, hence, it maintains the family united. For the government, the confinement of all offenders in prisons and other institutions with rehabilitation programs constitutes an one-rose drain on the financial resources of the country. So that was chapter 3, which is the Provision Law of the Philippines under Presidential Decree 968 of Republic Act 19707. Thank you and keep safe everyone.